is again in session. Please be seated.
Thank you. We all in these times are at the mercy of technology. We did everything we could to be on time. Staff checked everything as recently as yesterday, but we apologize for the glitch through no fault of yours or any of our staff. Sometimes these things happen. At this point, you, Mr. Bowman, have completed, you've used all but 6 minutes of your time, and now, Ms. Mestermacher, please go ahead.
Good morning, Your Honors. May it please the Court. I'm Holly Mestermacher for the state. Can you hear me okay? Okay. The Circuit Court revoked petitioner's supervised release for the 4th time in less than 5 years. The resulting sentence was proper and it should be affirmed for 2 reasons. First, the sentence is proportionate to his ongoing and serious violations of supervised release.
I'm having difficulty hearing you.
Okay. Does it help if I move this closer? Can I move this closer? Does this help at all, Your Honor? Okay. The second reason the sentence should be affirmed is it's within the statutory limits and it's undisputedly not based on an impermissible factor. Turning first to the proportionality analysis, the sentence in question is, as petitioner appears to concede, within the 50-year statutory maximum under 62-1226A. And in this case, it's reasonable, both subjectively and objectively. And although petitioner appears to concede this is not a sentence that shocks the conscience, the underlying facts and circumstances and the pattern of severe violations is still necessary for the court to hear to understand how this sentence, the 25-year term of extended supervised release following revocation, it's critical in the state. In this case, we're not here on petitioner's first revocation, not his second revocation, not his third revocation. In less than 5 years, he had 18 serious violations. He went through 4 petitions to revoke. 3 of those were shocker sentences. The first revocation, he received 60 days. The second, 2 years. The second, 1 year. And now we're here because of the pattern of behavior, as his probation officer put it, his attraction to minors, his habit of hiding relationships, his using methamphetamine, which causes hypersexuality, and his ongoing pattern of conduct made him a very dangerous person. And the offenses, petitioner listed a few, but the severe ones weren't mentioned. His violations leading to these revocations include him admitting to having sexual relations with a 17-year-old, admitting to using an alias on an unregistered Facebook account to interact with a 13-year-old. He possessed sexually explicit videos and pornography of that 13-year-old and admitted that his intent was to have sexual relations with her. So this is when he's a grown man in his 20s at this time. And he also hid illicit relationships. He had in addition to the 2 minors, he was told not to have contact with a particular woman because she was a convicted drug felon. He continued to have contact with her anyway. And he continued this pattern without being deterred by the shocker sentences of incarceration. And based on deleting texts, photos, online accounts, emails, to avoid any detection, the probation officer recommended the full sentence, described him as very dangerous, and that nothing had deterred him to date. Part of the revocation was—
Counsel, you concede that there's a really big difference between 60 days or a year and 25 years.
Absolutely, but we're not here because of a few minor violations. We're not here in an isolated context. We are here because of the full pattern of what's gone on. This court has made clear, and the legislature has made clear, that extended supervised release is a critical part of the single sentencing scheme. This is part of the sentence. It's not some aside that the court has discretion to impose. It is a mandatory requirement. And the legislature crafted the statute in a manner to allow the body with knowledge of the facts and the circumstances of the offender in the case to determine what the appropriate measures are to both protect the public and deter and modify the behavior of the petitioner. And that's what we have here. So we're not just looking in isolation. We're looking at the entire pattern of conduct going back to the underlying offenses. And to your Honor's question about whether that can be considered, it can. And this court has said as much, or at least indicated as much in at least two decisions, State versus O'Neill, State versus Marlowe P. in 2024. And since then, emphasizing that, yes, we're not going to look at this in isolation. This is part of the original sentence, and those facts and circumstances can be considered here. And those facts and circumstances present a very alarming picture. It presents a picture of, as the probation officer described it, as somebody who is highly attracted to females. And that has not been abated by the shocker terms of incarceration. So,
Counsel, I want to make sure that I'm clear on the nuance of the state's position as to how circuit courts should consider the underlying conduct. Are you arguing that the circuit court should be able to consider the underlying conviction conduct in a manner of sort of assessing the risk of reoffense? Or should the court consider it in a sort of, well, you didn't get enough for that underlying offense. Let's look back at how bad it was. How exactly are you arguing that circuit courts be directed to look at the underlying offense?
not the latter, Your Honor. We've got the statutory penalty for whatever that qualifying offense is. And basically the legislature has said, regardless of what the sex offense is, you have to have this additional term. But the circuit court it can consider the facts and circumstances, how it weighs them. We're not advocating that it uses the extended supervised release for anything other than what the legislature has said that it's designed to do.
Well, counsel, I saw in your brief that you argued essentially, well, he could have gotten 100 years for the underlying offense, so this can't be disproportionate.
I think the point in that argument, Your Honor, is that it's still part of the pattern. It is going to assess risk. I mean, this fella, it's not just that he had a small incident involving minors. This is an ongoing pattern that first began with the convictions and has continued into the extended supervised release unabated. The circuit court, in this fourth revocation, after hearing the testimony of the probation officer and the arguments of counsel, articulated that if there's a program to cure pedophilia, he would certainly provide that to petitioner, but the court recognized or articulated that the pedophilia isn't something you can cure. It stated the petitioner has an obvious problem with it and noted the long history of it. So that was certainly a factor that weighed in assessing the risk to the public. And just to be clear, the 25-year term of extended supervised release, that's not written in stone. The legislature has, again, given the circuit courts the discretion to modify it and to terminate it as needed based on a particular offender. Offenders have different needs. So if after this term of incarceration on this revocation, the petitioner comes out and he's complying with the terms and conditions, and there's no more fear of whether he's going to be preying on minors or endangering the public in some effect, the circuit court has full authority to either lessen that term of the term of extended supervised release or terminate it. So yes, it's imposed at this point, but it provides flexibility to help a sex offender integrate back into the community after a term of supervised release, while at the same time trying to modify the behaviors to protect society.
Counsel, doesn't it also set the potential for an additional period of incarceration up to 25 years to be imposed on subsequent revocations?
Yes, Your Honor, it does. And that was contemplated by the legislature. With the way the statute is written, the legislature contemplated a person being required to serve up to that 50-year max if they are not able to comply with the terms and conditions of supervised release.
Counselor, can you address the arithmetic of the credit to which he's required to be given under the law in the context of what the trial judge did?
Yes, Your Honor. So under subsection 621226, we've got a few interconnected parts. We've got subsection A that I don't hear an echo. You might not be able to hear me anymore. We have subsection A which requires the court to impose a term of supervised release up to 50 years as part of the sentence. In this case, as part of the underlying sentence, the court imposed 25 years. it falls within that parameter. Subsection H3 gives the circuit court authority to revoke supervised release and require a defendant to serve in prison all or part of that term. Now, it caps that term of imprisonment at the term that was imposed at sentencing, so the 25 years. Here, the circuit court imposed a 25-year sentence, which matches what it imposed at sentencing, and then it reduced that by 5 years of credit for an effective term of imprisonment of 20 years. Subsection J authorizes a court to place an offender back on supervised release after revocation if that sanction was less than the 50-year maximum authorized by the statute. I feel like I need a flow chart. The new term can't exceed that 50 years. So whatever the term of imprisonment, in this case 20, reduce the 50 years by that. So it leaves a 30-year term for extended supervised release. On this new revocation, the court imposed a 25-year term.
So do you believe the circuit court had authority to give that 5 years of credit? Where does that come from?
The circuit court had authority to give credit under J, where the J specifies that the term of incarceration upon a revocation needs to be used to reduce the term of extended supervised release.
Well, is that the term of incarceration for his violations? In other words, in this case, 3 years and 60 months, or 6 months, or whatever. Or is it the 5 year, the 10 years that he served, and he actually killed that sentence by serving 5 years, which was the underlying sentence? He gets credit for that?
No, Your Honor. The credit the statute authorizes is credit for the term of incarceration served upon revocation. Oh, I think we went out. It's for the term of incarceration upon revocation. It's that sanction as
So
opposed
the
to.
5 years credit that, in this case, that the judge gave, which was part of his original sentence, the judge shouldn't have done that.
This court has said that courts can't give double credit for the sentence, basically. You can't use your term of incarceration on the sentence to fulfill another term of incarceration on the same sentence. This court made that clear in State versus Winning, but regardless of how the circuit court labeled it in this case, still gave him 5 years credit. So regardless of how he termed it, that 5 years credit was applied against the sentence imposed on this fourth revocation, reducing it to an effective term of 45 years.
You'll concede, though, that that wasn't consistent with the way the credit should be calculated under subsection J.
I will agree that subsection J specifies that it's the term of imprisonment imposed upon revocation that's used to reduce it. And in this case, the term of incarceration that was imposed was the 25 years minus the 5 years for a term of 20 years. That was the term of imprisonment.
Yeah, but he didn't have 5 years of credit. If you add up all the time he was in jail for his revocations, that does not equal 5 years. You agree with that?
Correct. Yes, he got more than he may have been entitled to under subsection J. Under subsection J, if he'd been entitled to the credit for the time served on the prior revocations, approximately 3 years and 2 months, that would have been what the court could have deducted from J. As it is, the court deducted 5 years of credit he wasn't entitled to. So that essentially, it's greater than what he could have gotten had the court stuck to the letter of how the statute is written.
Counsel, if we send this back for what I think everybody in the room concedes is a miscalculation of the amount of credit, could the petitioner get essentially more time?
Yeah, first, Your Honor, just let me say that petitioner has not challenged the court giving him those 5 years of credit on appeal. He's perfectly happy to take those. But yes, I believe the effect would be that if it was sent back for resentencing, according to how the statute is written, it would be a 3 year and 2 month credit as opposed to the 5 years. And just H3 and J, they're intertwined. So where you have one that's higher, the other is lower. In this case, the circuit court reduced the term of imprisonment by 5 years, which in turn elevated the amount of available time for extended supervised release. So it took the 25 years down to 20, and when you subtract the 20 from that 50-year umbrella, you get to the 30 years that the court could have to impose extended supervised release. The converse of that is if it is sent back down and this court says you can't give him that 5 years credit, then the term of incarceration goes up to the 25 years that the court imposed. And on the opposite side of that is the available term of extended supervised release would then be decreased to 25. And any credit of 3 years and 2 months would be used to reduce that. So you're wishing I had a whiteboard, don't you?
I have a question about that, though. So as far as the periods of extended supervised release, the revocation, additional terms of incarceration, he already used 60 days a year and 2 years of that. So how did he have 25 years to impose as the sentence at that time when he's already used some of that time previously by imposing additional periods of incarceration pursuant to revocation?
It's kind of a numbers game, Your Honor, because the court did give credit for 5 years. So regardless of the timing of when it gave it or how it gave it or how it labeled it, it gave him 5 years credit over and above the 3 years and 2 months.
Well, credit for time served doesn't change the sentence. If we look at it just in a sentencing standpoint, you have the sentence in the 1 to 5. Credit for time served doesn't go to reduce the 1 to 5. It goes to reduce the actual time spent. And that's what, I think there's the semantics here of referring to this as credit for time served versus an offset on the bank of supervised release time that could have been imposed as additional period of incarceration. Those are two different, as I look at it, two different concepts.
They are, but in this case, subsection J specifically allots for that. It carves out the exception saying, you're going to get credit to reduce this.
That's only on extended supervised release after the fact.
It is.
It's not on the sentence that was imposed pursuant to the revocation.
That would be something for the court to clarify, Your Honor. So I don't have an answer for that. I don't believe it's ever come before the court in that context before. But in this case, the state's position is, regardless of how the circuit court calculated the credit or applied the credit, the net effect is that it is less than that 50-year maximum, a point which petitioner doesn't seem to dispute at this point. And that sentence should be affirmed. And turning back to the proportionality issue, the 25-year term of extended supervised release is, again, important in this context. Looking at the legislative purpose behind it is the legislature's determined that sex offenders require supervision above and beyond incarceration. And in its role to define and punish crimes, it did so here by making extended supervised release a part of that single sentencing scheme. This court, the legislature, have recognized that sex offenders have one of the highest likelihoods of reoffending once they are out of custody, and that's a tendency that persists over time. And indeed, we see that here in petitioner's case. It persisted after he was released from incarceration initially and on the first revocation, and then to get us to where we are today. He continued to persist in that behavior. So supervised release is a means to provide treatment to help the defendant transition back into society with the goal of modifying that behavior to also protect at the same time. It's two-part. It's not just we're going to punish him. It's, he's had this sentence. Legislature's recognized, this court has recognized that an offender needs more help in addressing the underlying behaviors that got him there. And again, these are assessed on a case-by-case needs basis, and that's what the legislature has written into the statute. Is it gives the circuit court the ability to assess a case on the needs of a person and modify the sentence as needed, impose a sentence as needed to really achieve that goal of safety and integration back in the public. And this court has, on the other Wayne Street factors and comparing punishment, which would be inflicted in other jurisdictions, this court spoke on that in both Marlowe P. and O'Neill, and basically recognized that most jurisdictions have supervised release in some term. Some have greater terms, some have lesser terms. Ours is not really an anomaly either way. But in comparing petitioner's situation with offenses, other offenses in West Virginia, I think it's important to note that he is one of the only offenders that has actually made it to a fourth revocation. I've not seen a case where an offender was released from a third revocation back into general populace and then had another revocation. Petitioner is the only one I see. If you're looking at the cases this court has decided, when Marlo P., his 50-year term of extended supervised release was revoked on a first revocation, and that revocation was based on testing positive for marijuana and being discharged from mandatory sex offender treatment. Here, we have a defendant who has violated supervised release 18 times in manners directly related to the issues he was having, being attracted to minor females, drug addiction, dishonesty. This court has categorized deleting text messages, photos, email.
Counsel, you have about 30 seconds.
Okay. Your Honors, the state believes that the circuit court imposed a sentence that's lawful. It falls under that 50-year maximum and necessary to protect the public from petitioner and his refusal and inability to comply with the terms of supervised release. The sentence should be affirmed. Thank you.
Please, court, I don't have a great deal to add other than I'm not here to throw my client under the bus, but I have to deal with the facts and the law as I have them here. I think that Mr. Bradigan is entitled to, if I've been representing him, I told him to leave this alone because I didn't want to get up here and have something happen to the 5 years that he got. That 5 years is better than 3 years and 60 days. But given that, he should get credit for it somewhere, whether it's on the, in the way I read the code, it's going to be on the, if he gets supervised release, he gets credit for that because that was part of the penalty. But he should get credit for it somewhere, whether it's off his sentence. What corrections has done, they have taken the 5 years off, and that's how they've calculated his discharge date and his pro-eligibility date.
Didn't he already get credit for that on his original sentence that he discharged
He did.
prior to supervised release starting?
He had 5 years, he did 5 years, and that's how he discharged it, the original sentence. I don't have really anything to add, or any questions, or
Are there further questions? If not, thank you, sir. This case will be submitted.
Next case for argument. Next case for argument, Stafford Glenn Poff and others, the Wayne County Commission, number 24105. This matter is a certified question from the Circuit Court of Wayne County. This matter comes to the court under Rule 20 of the Rules of Appellate Procedure. Under Rule 20, each side has 20 minutes to present their arguments. For the petitioner, that 20 minutes includes both opening and rebuttal. Counsel for the respondent have split their time, 12 minutes to Mr. Arsenault and 8 minutes to Mr. Lane. Counsel for the petitioner, you may take the podium and proceed.
Good morning. May it please the court. It is an honor for me and my counsel, Dwight Staples, to represent 3 former deputy sheriffs of Wayne County. The first, Lieutenant Sharia Maynard, had worked for 19 years when the issue before the court arose. The second deputy sheriff is Sergeant Glenn Poff, Stafford Glenn Poff, who worked for 15 years for the Wayne County Commission when this issue arose. And noteworthy is before he started working, he had a 40,000 plus year job with bonuses with Columbia Paints. The third plaintiff that we represent is Captain Chester Maynard, who worked 18 years when this issue arose before the court. And at issue are 3 policies that were in effect during this time, over the course of the years. The first policy provided for, after 20 to 24 years of service, if you retired, your health insurance benefits would be paid, your premium would be paid 90% by the Wayne County Commission. In 2011, they changed that policy so that anyone hired after July 2011 would not receive health insurance benefits. It did not change the health insurance benefits that the plaintiffs received. Then, in July of 2017, the Wayne County Commission voted to change the health insurance benefits so that individuals would have to work 15 to 25 years, to get 50% of the premium paid by the Wayne County Commission, and 25 plus years to get 100% paid. That is the matter before the court today. The circuit court answered 2 certified questions. The first question involved whether or not the plaintiffs could pursue a claim based on a vested right. The circuit court said no to that question. The other question was whether or not the plaintiffs could pursue claims in contract, breach of contract, detrimental reliance, unjust enrichment, false and misleading statements, and quantum merit. And the court answered yes to that question. So we're here today to assert our clients' claims for not only the detrimental reliance contract, unjust enrichment, quantum merit, and false and misleading statements, but also the vesting issue. I'll start with the breach of contract. The contract occurred when the Wayne County Commission presented and offered to these deputy sheriffs a written promise to provide health insurance benefits when they retired. After at least 20 years of service, they would pay 90% of their premium.
Counsel,
Yes.
isn't it a disputed fact below whether or not there was in fact a contract, and aren't there competing motions to that? And if so, if it is disputed whether or not there's a contract at all, can this court even answer the questions before it?
Well, there was a contract. There's no question. It was a written promise. It was in writing. And courts have decided previously that a unilateral contract can be accepted by an employee if they offer something by continuing to work. Consideration and acceptance was clearly given by the deputy sheriffs by continuing to work at what is clear and obvious low and artificial wages. And the Wayne County Commission certainly reaped the benefits of them working. So yes, there was a contract. And there are no questions that a public employer has the right to unilaterally modify a contract, but it can't retroactively impair previously earned rights. These people were one of them was 1 year shy of receiving this benefit when they changed the policy. Now, the Wayne County Commission, they never had to make that promise. But once they did, it is our belief that based on Article 3, Section 4 of the Constitution, specifically says no law impairing the obligation of a contract shall be passed. So that's what we have here. In the case cited by the defendants, I think it's Marshall versus City of Huntington, that case is distinguishable because in that case, there was a collective bargaining agreement, and it was only set for a certain period of time. And in that case, the court ruled that the city had a right, in the absence of a written contract, to not provide the health insurance benefits to the petitioner in that case. There was no collective bargaining agreement in place at the time he sought to collect the benefit. So that was controlled by a contract that no longer existed. So the court properly ruled in that case, there was no written contract. In this case, there was.
Counsel, you
Yes.
agree that West Virginia Code 7520 covers this issue of health insurance that can be provided by a governmental entity, i.e. the county commission? You agree with that?
I agree that 7520 authorizes counties to purchase group insurance. They can purchase one, they can purchase two, or any combination. I do agree with that. However, that doesn't restrict the commission from purchasing a policy where they'll pay 100% of the policy or 0% of the policy.
Yeah, well, the part I'm looking at is the last paragraph in section 20, and it says, when a participating officer or employee shall retire from his office or employment, he may, if he so elects and the insurance carrier agrees, remain a member of the group plan by paying the entire premium for coverage. Does the county commission have the right to, statutory right to enter into a contract that statute seems to say it can't? Because it says that if you're retired, you gotta pay the whole premium.
It does say that. However, I think prior to that, if you read the whole statute, it says the commission can negotiate whatever type of policy they want. And not only that, what's interesting in this case is that not only did the commission, the Wayne County Commission, pay previously 100% of the premiums for retired employees after they reached so many years of service, they still do. The policy is still in effect. They're paying 100% of retirees with 25 years of service.
Well, my point is, isn't that, or could it be argued that that very act of paying 100% for certain employees that are now retired is an ultra vires act by the commission and therefore void?
I think that the statute, if read in its totality, allows the commissions to negotiate. It specifically says to negotiate, to pay a portion or all of it. And if they decide that the policy that they want to purchase for retirees, they're going to pay 100% of it, then I think that statute authorizes them to do it. And clearly Wayne County Commission feels like they can because they've been doing it for the last 20 plus years and still doing it. So I think if you have to read it in totality, that if they negotiate that policy so that they're paying 100% premium, which they are, then they're allowed to do that. So I think that 7520 is applicable, but if you read it in its entirety, that they're allowed to do that. I also would like to say that with regards to the vested rights of the Wayne County deputy sheriffs, these sheriffs believed and they relied on the written and the verbal. They would have commission meetings where they would address the commission and the commission would have them step to the side and say, we can't talk about this in public. But remember, we're paying you these low wages because, hey, down the road, we're going to pay 90% of your health insurance premiums when you retire in 20 years. So just hold steadfast because we're going to do that. And they relied on that. They relied on that. And A property interest right includes benefits to which an individual may be deemed to have a legitimate claim of entitlement under existing rules of understanding. Nothing could be more clear in this case that these deputies had a property interest right to these benefits when they retired. Did they detrimentally rely? Well, of course, we have case law that says, even though it was a pension case, that 10 years presumed detrimental reliance. These plaintiffs worked for 19 years. They were one was 1 year shy of getting that benefit. One was 18 years, 2 years shy. And the other that we represent had worked for 15 years. So yes, they certainly came under the detrimental reliance. The commission has been unjustly enriched. These people sacrificed their lives for the safety and welfare of the citizens of Wayne County. And as admitted by the former Wayne County Commissioner and former Sheriff Dave Pennington, the plaintiffs were paid lower wages than other counties. For example, he was also previously the sheriff in Cabell County, and he knew that they were being paid less than other counties. False and misleading statements, yes, no question that they were induced to work for the Wayne County Commission, to work at lower wages, and in turn to receive these health insurance benefits, that the representation to them was material, but it was subsequently false. That the deputies relied upon it, not only because they were told by the commission and former sheriff, but it was in writing for all these years, up until 2017 when it was changed.
Counselor, has the lower court made findings on those matters that you just asserted?
Yes, on the issues, the court ruled, the court denied the defendant's motion to dismiss on all these issues. And he clearly stated that they had causes of action for everything but the question of the vested rights, which we believe they did have vested rights. Although, there's a lot of argument that vested comes into play when it's a pension. None of the cases, though, they include pension, but they don't exclude health insurance benefits. And there has been case law to say that health insurance benefits are clearly a property interest that should be honored. Additionally, and I would like to applaud the court's instruction in Kent v. Sullivan. Prior to that discussion, there really didn't appear to be any consistent analysis on the immunity issues. And in this case, the commission asserted that the common law immunity applied. And of course, we know that to be incorrect because it only applies to state entities, not political subdivisions.
Counsel, I saw in the briefing that there's some mention of immunity issues, but I don't see that as being any part of the certified questions before this court. And similar to my question earlier, can we even get to these questions if immunity issues haven't been settled, when there's pending motions for summary judgment? I understand that you said that a motion to dismiss has been denied, but that's a very different standard.
Yes.
We're just assuming all your allegations in the complaint are true at the motion to dismiss stage versus motions for summary judgment, which are pending. Again, aren't you just asking this court to prejudge and pre-rule on those pending motions for summary judgment?
No, what we're asking for is the plaintiffs to be allowed to move forward with those claims. The defendants assert that we should not be able to move forward, but we believe, based on the evidence and the facts in this case, that we can move forward on those issues.
Is it proper for this court to look at unsettled, in your terms, evidence and facts in the context of a certified question?
And when you say disputed facts, I'm not sure which ones you're referring to, because there's no dispute that these insurance representations were made. The documents are there. There's no dispute about that. There's no dispute as to when the deputy sheriffs worked, how long they worked, and when they stopped working. So it's a matter of whether we can proceed with those And as far as any damages set forth or anything, or any issues, that would be a determination by a jury. I'm not,
You have 3 minutes and about 40 seconds.
okay, and I'll hold that for rebuttal. Thank you.
May it please the court, Webster J. Arsenault, along with Jacob Lane here on behalf of the Wayne County Commission. I got my outline all prepared, but I'm going to deviate it based on these questions that have been asked. We argued the motions for summary judgment several years ago. The judge never would rule on those. We were trying to get the case resolved. He was setting it for a jury trial. To me, it made no sense to have a jury trial on this, which I thought was primarily a legal issue. The vesting is clearly a legal issue. That's the first certified question. And there is no case, and you notice that Ms. Henderson didn't cite this court to any case, that says that there are vested benefits here in the form of deputy sheriff retiree health insurance. When you look at all the vested benefit cases, they relate to pension benefits. Booth versus Sims is the case that they rely on. And when you look at the Marshall versus City of Huntington case, Judge Howard below issued an opinion that this court later affirmed. He issued his opinion in 2019. It's in the joint appendix. It was attached to our motion for summary judgment. And this court later wrote a memorandum decision that said he got that legal issue right, that there was no vesting for health insurance benefits. She tries to distinguish that case and say, well, it had to do with a collective bargaining agreement, but the decision he made had nothing to do with a collective bargaining agreement. He distinguished Booth and said health insurance is different than pension benefits and it doesn't vest. Why? When you look at Booth, and everybody here knows because they participate in the retiree insurance program, so much is put aside by the employee, and Booth at 6%, they talk about the employee, and the employer puts aside 12%. And then there is a plan that says X years of service and certain age, and you get Y benefit. And everybody knows that, and that's a fixed benefit. And one of the things that Judge Howard talks about in his decision is there is a difference with regard to health insurance benefits because it's not a fixed benefit. It changes every year. The premiums go up every year. We just had in the news last week about PEIA and the increased premiums that everyone will have to pay. Further, the record in this case reflects, and it's in Mr. Boggs' affidavit, and Sharia Maynard agreed with this, from year to year, the commission would have to look at its budget and they would have to say that we can't afford what we did last year. And so we're going to have to start changing things. And they would change things like the prescription drug plan, the co-pays, and other things. So that's another distinction to show why this is not a vested interest, and it has never been held by any decision of this court that retiree health insurance is a vested benefit. And this court needs to be careful because, as I just mentioned, PEIA changes things from year to year. And if this court is going to hold that it is a vested benefit, then you're telling PEIA that they cannot change it. We believe that is entirely a different benefit, and it should be held as a matter of law that that is not a vested benefit. And then when you decide that issue, we think the case is over.
Counsel, isn't that skipping over the threshold issue of whether or not this policy created any kind of contractual relationship?
Well, you have your decision in Collins that talks about a long-standing policy is not a contract. And when you listen to what she is saying, and there's a promise, there's no promise here. And the both Poff and Maynard agreed that there was never any promise made by any commissioners or any sheriffs. All that they were done is they were handed a policy.
So, counsel, you'll agree with me that it's disputed in this case whether or not there's any contract created by this policy. You're saying no, petitioners are saying yes.
Yes, because we're saying it's a legal issue. And under Collins versus City of Bridgeport, it is clearly held that even if it is a long-standing policy, there can be no contract. And it is not an impairment of contract to change a long-standing policy with notice to the employees. And that's exactly what was done here. There's no dispute of fact about that. When you read the depositions, there's no dispute of fact that nobody was promised anything. When you read the depositions, there's no dispute of fact that nobody had a written contract here. The only thing that she is saying as the promise is that the policies were promulgated by the commission. And we say as a matter of law under Collins, they had the right to change that. Further, to the extent that she wants to say that the sheriff or somebody or the county commission said, oh, we're paying you low and you're going to get this benefit in the end, Darlington versus Magnum says that you cannot rely upon those kind of statements. Going back to where Justice Hutchinson was, 7520, we believe controls here, and it clearly says that the retirees to pay for their policy. So it was a void act, in our opinion, what the Wayne County Commission did, and they have no legal right to argue that they have some entitlement to this benefit. And so we think that this court can address these certified questions and can provide some guidance in this situation.
Counsel, I have just a little bit of a procedural question. So it was a joint motion to certify, and the certification order from the circuit court doesn't have a lot of analysis in it.
Yes.
Were the questions drafted by the parties and submitted? Were they significantly changed by the circuit court? How did the certification order get in the form that it's before this court?
Mr. Staples and I negotiated the order that was presented to the court. And we did this as I have done with other certified questions. And you know, the court has to answer the questions under the rules. And so we presented the two questions with a yes or no, and then you see that the court answered each of those questions by checking in the boxes. So other than that, it was a process of negotiation, what Mr. Staples and I could agree to be put in a certification order.
Thank you.
The other issue that I want to touch on is their reliance on Waite versus Civil Service Commission. They argue that there are property interests here. And in State XRL Anstey versus Davis and Collins versus City of Bridgeport, this court has defined what is a property interest. And it says you must look to state or federal law. And so we argue there is no property interest here because they're looking at these policies promulgated by the commission. When you look to the state law, 7520 says that the retiree is to pay. Excuse me. Contract issue. Justice Bunn, you mentioned that there is no findings on this. They make arguments, CityNet versus Tony, and that case is clearly distinguishable. There's no written contract here at all. And in that case, there was a written contract and it said you had a vested benefit and it was a bonus and it was calculated and they said it would be paid at retirement. There's nothing like that here. There's been nothing set aside by these employees that would enable them to say that they have a property interest in this. Waite versus Civil Service Commission is a civil service case, and whether an employee who was suspended for less than 30 days had notice and a right to be heard. There was no dispute that those civil service employees had a property interest, and that's what the court found. In this case, we don't think there is any property interest at all. Also, there's a statute of frauds problem. As we mentioned, 55-1-1-F says that in the event that there's going to be a contract that's to be performed within a year, it need not be in writing. Well, these contracts are something that was to go out for 20-year period. You didn't vest in this payment of 90% until after you had worked 20 years. So clearly, that is not a contract that is capable of being done within 1 year. I want to touch, as I said, I jumped from my outline. I want to touch on a couple other things. One of the things that Ms. Henderson left out when she was mentioning the policies of the county, she failed to mention that there was another component, and that is the age component. And, excuse me, that's an important point here. The original policy said that you had to reach age 50 before you would have the 90% or the 100% payment of the premiums. And the policy in 2017 was changed so that it was age 60, and then they would pay 50% for 15 to 25 years and 100% over 25 years. So that was the change that they made. And I want to point out that that change was made not out of any ill will towards any of the deputy sheriffs here. As Sharia Maynard admitted in her deposition, there was a budgetary constraint. And you'll see the acronyms OPEB and GASB in the record here. And that's the Government Accounting Standards Board. And the record reflects that there was a gentleman, Robert Crabtree, with a group called Benefit Solutions. And he would regularly go to the commission meetings, and he would give them the GASB reports. And County Commissioner Kenneth Adkins testified that they reviewed those GASB reports. And so those reports led to the changes here because they were looking at those liabilities and their budgetary restrictions.
You have less than 30 seconds.
Yes, I was going to wrap up. I was going to say, unless there's any other questions, I'm going to wrap it up. We appreciate the opportunity to present these certified questions. We hope that the court will affirm on the first certified question and reverse on the second. Mr. Lane's now going to discuss in more detail the second certified question.
Mr. Chief Justice, honorable justices of the Supreme Court of Appeals, may it please the court. My name is Jake Lane, and I represent the Wayne County Commission along with Mr. Arsenault, and I will be discussing the second certified question pending before the court today. As Mr. Arsenault aptly explained, the central issue in this case is whether the Wayne County Commission could change its 2011 policy of subsidizing retiree health insurance benefits for deputy sheriffs. As it relates to the second certified question, the plaintiffs assert that that policy can be enforced through claims of detrimental reliance, unjust enrichment, quantum merit, breach of contract, false and misleading statements. The circuit court answered that question in the affirmative, and we assert that the circuit court erred and this court should answer that question in the negative. It's black letter law in West Virginia that county commissions have limited powers. A county commission only has the power conferred to it by the people through the Constitution and by the legislature through the West Virginia Code. County commissions can only do those things authorized by law. And county commissions can only do those things in the manner or mode prescribed by law. This much the court has said in Berkeley County Commission versus Shiley. And there are two statutes at issue in this case that stand for the proposition that the county commission has no lawful authority to do the things that the petitioners ask the court to order it to do. First is West Virginia Code 7520, which you asked the question about, Justice Hutchison. This is a 3-paragraph statute. Its text is plain. It does not authorize a county commission to purchase health insurance coverage for retirees. I'm going to break down that statute just briefly. The first paragraph authorizes counties to purchase group health insurance for officers and regular employees. The second paragraph permits county commissions to pay all or part of the premium for officers or regular employees. This paragraph, which is cited to by the plaintiffs and the petitioners in their reply brief, does not discuss the county commission paying premiums for retirees. It's not until we reach the third paragraph of West Virginia Code 7520 that retiree health insurance is mentioned. And in that paragraph, the statute says that an employee who retires may elect to remain on the group health insurance plan as long as the insurance carrier agrees with that, and the employee pays the entirety of the premium. There is zero mention in the statute of the county commission being permitted to pay all or part of a retiree's health insurance premium. Now, the petitioners cite to West Virginia Code 812.8 as persuasive authority for interpretation of West Virginia Code 7520. And 812.8 is essentially the corollary statute to municipalities buying health insurance. The petitioners state that 812.8 is almost identical. It's not in many respects, but most critically, it's not in the respect concerning retiree health insurance.
Counselor, let me interrupt you for a second before you do your analogy about the municipal statute. I think I understood your opposing counsel to say during the first part of our argument that notwithstanding the statute you both talked about, Chapter 7, that the Wayne County Commission has and is continuing to pay retirement, to pay health insurance premiums for its retirees. Is that correct?
That's correct, Your Honor.
How do you reconcile that with the prohibition you just mentioned in the statute, the one that Justice Hutchison asked about earlier?
Well, I think if you look at the Darlington versus Mangum case, this court's case, it's directly on point. And basically in Darlington v. Mangum, the county commission in that case promised in a handbook to pay 100% of health insurance premiums for deputy sheriffs. There were budget constraints that came up. This was revised the next year, and the deputies sued. And one of the principal contentions of the deputies were, hey, you all have done this. You've promised to continue to do this. The sheriff and the previous sheriff has even promised this to us. And what the Darlington court said was, well, if the promise is in violation of the statute, if it's contrary to the statute, then the county commission can't be bound by that promise, even if the county commission is acting outside of its authority. So it's our position, Your Honor, that the Darlington case would control, and no matter what the county commission has provided, a court of law can't order it to provide something it's not authorized to do under the statute.
So even if I understand what you're saying, even though it would seemingly be to be outside the statute, you're saying the county commission can do it, and it can stop anytime it chooses to stop, deciding it can no longer afford to do it?
Correct.
Thank you.
Well, would that, even if we assume that it was an ultra vires act but they have done it for a period of time, if the law would say to the county commission, you're not supposed to be doing that anyway, and the court would say that the county commission can't be sued to continue those payments, would not the sheriffs and the employees have a right to say, hey, we are damaged by your unlawful act, therefore we can sue for detrimental reliance and false statements and that sort of stuff and recover damages. Maybe we don't get an order that says you got to continue to pay our insurance, but could not the employees have a cause of action that says, hey, we detrimentally relied on your illegal conduct, that we didn't know was illegal. Therefore, you owe us damages, not necessarily an order from a court that says you got to continue to pay it. Could they be, do they have a cause of action, I guess is what I'm asking.
We assert that they do not, Your Honor. And the reason for that is, let's take the detrimental reliance claim, for example. We assert that a person can't reasonably rely on an act that would be contrary to statute or an act that would be unlawful. And also, this would be essentially asking that the 2011 policy be enforced through money damages, regardless of whether there's an actual order enforcing the policy. It would be de facto enforcing the policy through money damages.
So your argument is essentially the county commission can do it when it wants and not do it when it doesn't. So what if the county commission decided, you know what, we're not going to pay those former women deputies, but we're going to pay the men because we just like it better? I mean, at some point, where's the end of your argument?
I would certainly advise the county commission not to do that, and I believe that that would violate anti-discrimination statutes under federal and state law. But the county commission, in this case, has tried to provide a benefit to deputies that it turns out it didn't have the authority to do. But a court of law could come on later and say, well, you're acting outside of the scope of your authority, and order the county commission to not do that. So that's our position with regard to whether the county actually has the authority to purchase the health insurance.
Counselor, you agree, I presume, with your co-counsel that there is no basis for, that there's no contract that existed with these employees for future benefits, and disagree with your opposing counsel on that question, I assume. How can this court resolve that without an underlying finding and judgment by the circuit court? Doesn't the lower court have to answer that question before this court should get involved in trying to answer a certified question that necessarily embraces that?
I would say typically yes, Your Honor, but in this situation, the act that we're discussing would be an act that's contrary to law, so it's a legal matter for the court that the court can determine as a matter of law.
Thank you. Other questions? Your time's expired. Thank you,
Thank you,
sir.
Your Honor.
Chief Justice, I believe you said I had 3 minutes.
Yes, ma'am.
All right. So I think the most recent discussion highlighted our point exactly. The county is picking and choosing who they pay and when they pay. They've been paying, they're still paying 100%, yet in this case, we're talking about 3 individuals. We're not talking about 20, 30, 40 people who had detrimentally relied upon this written and verbal promise or policy, written policy, to provide them their health insurance benefits. And Collins is distinguishable because there are very few people that the retroactive that were retroactively impaired. We're talking about, as far as we're concerned, our 3 plaintiffs. So additionally, there was no promise. It was a contract. The court said in the denial of the motion to dismiss that there was a basis for a contract. The commission voted on it all 3 times.
Counsel, let me ask you a question. Isn't there a question here in this case that's kind of fundamental? I have your petitioners vested. You've indicated that one was 1 year, one was 2 years. So if they've not reached the vesting part of this argument, how is there a case out there?
Well, I believe that they have the property interest, right? That they have a legitimate claim of entitlement under the existing rules of understanding through the policies. That they relied on that was vested. They were vested, as far as we're concerned, because they relied on it. It was a legitimate property interest for
But
almost.
they had not yet vested to receive the benefit. Is that a fair statement?
I think it's a fair statement that they could not receive the benefit until they reached the 20 years, but that they had vested with regards to to a claim of legitimate entitlement to that.
Has the court has the court below addressed that issue and talked about or made a decision as to whether or not they have a property interest and/or are they invested?
No, the court has not at length discussed that. No, it has not. And also, I beg to differ with regards to the Marshall case. We believe it's clearly distinguishable. It involved health insurance benefits, and the only reason why the gentleman was not allowed to receive it was because of a contract not being in place at the time. It wasn't because it was health insurance benefits. It was because there was no contract. So I would just like to conclude and say that for almost 2 decades, these deputies received lower wages. They forewent other employment opportunities in other counties with higher wages, all because they relied on, for almost 2 decades, the written and verbal representation that they would receive 90% of their health insurance premiums upon retirement after 20 years of service. Yes, the plaintiffs have been damaged, and we believe that these causes of action will allow them to address those damages, medical bills, longer work life, insurance premiums they've had to pay. So we respectfully submit that the plaintiffs, that you would answer both questions in the affirmative versus the negative. Thank you for your attention today.
Thank you, ma'am. This case will be submitted.
Testing, testing, testing.
Test 1, test 2, test 3. 1, 2, test 1, test 2, test 3. Testing, testing, testing. Test 1, test 2. Yeah. Test 1, test 2, test 3. Testing. Test 1, test 2, test 3. Testing. 1, 2, 3. Testing. Testing. Test 1, test 2, test 3, test 4. Testing, testing. Testing. Test 1, test 2, test 3, test 4, test 5.
Oh, you did hear it? Okay, testing, testing.
Again in session, please be seated.
Good afternoon, council.
Good afternoon, Your Honor.
Proceed.
May it please,
Next, if I could, sorry. Thank you, Ms. Tar. The next case for argument in the matter of Elizabeth Bozo. Okay. The next case for argument in the matter of Elizabeth Bozo, Magistrate of Nicholas County, number 24436. This matter arises under the court's original jurisdiction for judicial disciplinary matters. Under Rule 19 of the Rules of Appellate Procedure, each side has 10 minutes to present their argument. For the petitioner, that includes both opening and rebuttal. Counsel for the petitioner, you may proceed.
may it please the court, my name is Teresa Tar. I'm Judicial Disciplinary Counsel. And at the outset, I'd like to reserve 2 minutes for any rebuttal. We're here today because the question before the court is whether the recommended discipline is sufficient. And both sides have briefed that, and I will tell you that both parties agreed to a censure, a 2-month suspension without pay, and costs in the amount of $618.45. That agreement was adopted by the Judicial Hearing Board, and it's my belief that they adopted it because they thought that was the requisite or appropriate discipline that should be recommended before this court. When you look at the Cruikshank factors, it meets whether it was directly related to the administration of justice or the public perception thereof. I would argue that the conduct related to both, because we expect our court system is based on truth. And when somebody, particularly a judicial official, does not tell the truth, that does have an impact on our justice system. The second thing is whether it was personal in nature or whether it was related to a judicial officer's public persona. I would argue both in this case. It was personal in that it only affected her and it affected the court system as a whole. Nobody else was harmed by her conduct. They could have been, but she was not appointed, and it was caught fairly early on. And then it relates to the public persona of all judicial officials and whether they need to be truthful. Before she won as a magistrate in Nicholas County, she was a longtime magistrate assistant, and I would argue that they are held to this same standard that magistrates and other judges are held to, and that they need to be truthful when dealing with the public.
Counsel, on that note, so the rule 4.1 and 4.2 violations apply here to candidates for appointment.
That's correct.
How do we apply the rule 1.1, 1.2, and 2.16 violations to Ms. Bozo?
1.1, the rule is if you violate any state or local law, or you violate the Code of Judicial Conduct, you have violated Rule 1.1. So if you find that she violated the rule, then you can apply 1.1.
Where do I find authority for that applying to candidates for judicial appointment?
She was more than just a candidate, Your Honor. She started out as a candidate for appointment. Then she became a candidate for election in Nicholas County, and then she was elected. So at some point, she switched, and when she responded to us, she was a candidate for election. There's nothing that says that it does apply, but I think common sense dictates that those are catch-all. Rule 1.1, 1.2, and 1.3 are catch-all provisions, and those can apply to both candidates for office and officers, in my opinion.
So you'll concede, though, that Rule 4.2 is specifically made applicable to candidates.
Correct.
But I don't see anything in Rule 1.2 that makes it specifically applicable to candidates, and doesn't that suggest that it's not?
It doesn't say that it is, it doesn't say that it isn't, but those are general catch-all provisions. And the JIC has taken the position heretofore in other cases that it does apply in general circumstance issues.
When I reviewed what I think is the most recent judicial candidacy case, maybe the Callahan case, I don't see Rules 1.1, 1.2 applied there.
I don't think they were charged. That is correct, Your Honor. So if they weren't charged, they would not make the opinion. The next one is whether the allegations involve violence or a callous disregard for the system. Obviously, they don't involve violence, but I do argue that they involve a callous system or callous disregard for our system of justice. Because again, she's been in the system for quite a number of years, knows how it's supposed to operate, and knows that truth is behind and is what our system is founded on, basically, and stands on. Criminally indicted does not come into play here, but mitigating or aggravating factors, unlike Callahan, which was a 2-year suspension, Callahan fought the charges, would not admit to anything, and the opposing candidate was arguably harmed by the falsehood that was contained in the advertisement. This is a situation where she has cooperated with Judicial Disciplinary Counsel, has admitted her misconduct, has been remorseful for the same, and again, the only person that she heard outside the system the system as a whole was herself. This, in my mind, equates more toward the Pauley case. In Pauley, the individual was given 45-day suspension without pay for improperly handling a DVP situation and for also not being truthful with Judicial Disciplinary Counsel. What we have here is the respondent not being truthful with Judicial Disciplinary Counsel, but also she proactively sent an email to Judge Akers, who was the chief judge at the time, telling her that she was going to apply. And in that email, she said, quote, "I had moved to Kanawha County in 2021, and after transferring to Nicholas, I have maintained a residence due to wanting to run." That was not accurate. She sold her home in June of 2023 and then did not have any residence at all in Kanawha County from June until arguably she paid the magistrate assistant some money to rent a room from her.
You have 2 minutes left.
Okay. So I think that this case, in my mind, is more like Pauley, where there was some proactive outside intervention and then something else happened. And also in Pauley admitted his misconduct and was remorseful. And so based on that, I think that it falls within, and 60 days suspension without pay and a public censure is appropriate.
I know your time is running short, but I do have one other question.
Sure.
And you may have answered it, but I just want to be clear. So the 2.16A violation, are you relying on the statement to Judge Akers to sustain that violation?
No, in her response to us, she indicated that she had been working to find a place to live, very actively working. She never provided any information related to that. And then the other thing that she said in there is
There were text messages with multiple people in Kanawha County, weren't there?
there was one from November where she asked one person if she could live with them. The rent was too high, and they said no. That was one. The other one involved all of the same magistrate assistant who she was going to move in with, but she never did until January. So, and then the other incidence is where she basically, excuse me, said that she had reached the agreement with the magistrate assistant to move in last year. That was not accurate. It wasn't, the deal wasn't done until she made a payment. So, and that was in January of 2025.
Thank you. Ms. Bosso.
Thank you. My name is Elizabeth Bosso. I am currently magistrate in Nicholas County. In January, I did apply for the appointment in Kanawha County. My agreement with Ms. Trabert, we had worked out weeks in advance, just as an oral agreement between friends. We didn't have anything in writing. I had actively been seeking to come back to Kanawha County because of the work situation in Nicholas. It was hostile and unpleasant at that time. All I can say is the email that I did send to Judge Akers, I did say that I had maintained a residence in Kanawha County. That technically is not accurate. I did not maintain a permanent throughout the whole time. I had meant that I had made arrangements to have a residence in Kanawha County because I did try to come back. I was looking for employment back down here. My response to the JIC was completely inappropriate and unprofessional, and I am very sorry for that. It come as a catalyst for the chaos that was my life at that time, and I deeply regret it. It is not indicative of who I am. I do understand the importance of the public's confidence in our system. And as Ms. Starr stated, I have worked for the Supreme Court for the better part of 20 years as an assistant, as a senior status assistant, and for the past 15 months as magistrate of Nicholas County. I take my job very seriously. I love it. I've worked very hard to establish relationships with the agencies, the programs, and the citizens of Nicholas County. All I can say in my defense is I have learned so much from this process. I had never been in trouble before. I haven't been in trouble since this incident came about. I did not do due vigilance when it came to making sure that I would be eligible for that appointment. The opportunity came up and I jumped on it. And that clearly was not correct. I should not have done so. So again, I deeply apologize to this court and to our court system. My fellow magistrates and candidates, I did not intend to harm anyone. I figured, you know, when I found out that she had appointed Earl Whittington, I was, of course, disappointed. Part of the emails that I had turned in were just from one person, and that was my friend Kirsty Trabert, who I had the arrangement with. There were other assistants that I had talked to that had rental property, but they wanted a year-long lease, and without employment down here, I was not comfortable signing a lease. So this was an error in my judgment, and it is totally on me. All I can say is I'm sorry, and I ask that you will take into consideration, you know, my time with the Supreme Court, my almost 20, you know, better part of 20 years with working for the West Virginia State Supreme Court of Appeals, and that you will consider the fact that I have never been in trouble. I pray never to be in trouble again. I've definitely learned from this.
Thank you. Other questions? Thank you, ma'am.
Thank you.
Ms. Tarr,
I do not have anything else to add other than I would ask the court to adopt the recommended agreement. If anybody has any questions, I'll be happy to answer them.
other questions? Thank you. This case will be submitted.
Sorry.
Board is again in session. Please be seated.
Mr. Clerk?
The final matter for argument today, in the state of West Virginia, v. Augustus Calvin Gray, number 24145, is a rule to show cause in contempt against court-appointed attorney Ira Richardson. Mr. Richardson, you may take the podium. The rule to show cause under the court's jurisdiction allows an opportunity to explain why you should not be held in contempt. You have 10 minutes to present your argument.
Well, good afternoon, justices. I suppose I probably don't have a great reason. The case of Augustus Gray was appointed to me late last year to my office. At that time, it was myself and another attorney, Jordan West, working in the office. He was working as my associate. At that time, I had a pretty massive caseload, and we got started. It was appointed to me originally as a habeas, appointed by Judge Matish. At the time, Judge Matish was in his final months, if you will, of his career as a judge, about to retire. I believe in that time frame, Matish probably assigned my office 3 or 4 habeas petitions, probably in the last 6 months of 2024. Despite not being, despite never having solicited those cases from any court in Harrison County. So Jordan and I began working on the habeas. It became apparent that Mr. Gray had also filed an appeal, and he wanted both to go at the same time. We advised and received some advice from Judge Matish that we needed to file the appeal ahead of time or prior to the habeas. So we worked on that on January 17th, got the appeal filed. It was late, format was wrong. I'm sure you all are aware of that. Around the same time, Jordan and I are also participating in the Slowdown for the Holidays hearings. So we spent 10 days down here in Charleston defending the allegations that stem from that. Shortly thereafter, January 31st, Jordan leaves my practice. And so to say that my practice was in chaos at that point is an understatement. We've got all of Jordan's cases. We're trying to figure out which ones we need to withdraw from, which ones are we keeping, which, trying to unwind 5 years of Jordan working with us. The brief gets rejected. At the same time, Mr. Gray is writing letters to Judge McMunn in Harrison County, and to my office as well, hostile letters about accusations that I'm not handling his habeas case or his other case appropriately, that he's sabotaging his words in letters both to the judge and to myself, asking Judge McMunn to appoint new counsel. In March, Judge McMunn appoints new counsel on the habeas file. And part of what happened to me, as I didn't realize until maybe a couple weeks ago, that was just the habeas case number, not the this criminal appeal as well. It wasn't until speaking with one of the clerks of this court that I even realized, to be honest with you, that the order appointing us to do the appeal came in separate orders. I was under the impression that after Jordan spoke with Matish and we decided to do the appeal, that was our undertaking, not so much that Matish had entered a separate order ordering us to do the appeal. But nevertheless, that's kind of the long and short of it, really. Beyond that, I'm just incredibly busy. After Jordan left, I advised all the judges that we were working, the lists on to remove my office from their lists so that we were no longer getting court-appointed cases, but that still obviously leaves cases that remain that I didn't want to just withdraw from. So without Jordan, I just started working my cases. And an honest answer also is that it's hard to give time to this type of work, the appellate work that feels oftentimes pointless. I mean, both when you look at the record below what happened, because I was not his attorney below, Mr. Gray's, you look at the record below, and you kind of have a choice with the caseload to decide, am I going to work these cases where I might could still have some impact, or am I going to feel like kind of banging my head against this wall in this appellate practice that I'm just in all candor, it's not my strong suit, the appellate work. And I know some people think it comes part and parcel with taking court-appointed work, but I almost never have to do appeals for my own clients. It's always after some other lawyer has gotten a personal result that they're not happy with. And so I'm not trying to make really any excuses or anything. I did this morning make a sincere effort to get the last things that I need filed. I believe that I did.
When did you state that you became aware that you were responsible for this appeal? That you were responsible to perfect this appeal?
When you say became aware, I
thought you said it was a couple weeks ago you learned in talking with a member of our staff.
No, let me clarify that, if I may. When my office was first appointed, my understanding and recollection was that we were appointed as habeas, and Jordan and I were working that case and decided that it made sense to protect Mr. Gray's rights to finish and file the appeal first. And so in fact, I went to the prison to talk to him about that, about the fact that that's kind of the order of operations, and he was hostile at that point. I didn't realize, Your Honor, that decision, when we said, okay, we're going to work on the appeal, I didn't realize that there was also an order to that effect, such that when I saw the order in March comes across from Judge McMahon appointing new counsel to Mr. Gray, that I mistakenly thought that was on both the appeal and the habeas. And it wasn't until speaking the other day with one of the clerks here, I was advised, reminded, however you want to describe it, that there was an order specifically directing us from Judge Matish to do the appeal, that it was not a task that we took on just as a predecessor to the habeas.
Counsel, I understand your argument as to your confusion about the March order 6 months ago. But now, in September, you have been served with a notice of intent to sanction in April, giving you until May 1st to perfect this appeal, an order from this court. And then on May 16th, we have a motion to dismiss. And then on June 25th, you had a rule to show cause issued against you. And now we're in September. How do you explain, at the very least, from June 25th until today, not filing what this court ordered you to file in this appeal?
I don't really have some great explanation. I don't. I chose to do other things. I chose to do things that I felt more important, more substantive, more impactful, not a waste of my time. The appeal of Augustus C. Grace is an absolute waste of my time.
Did you ever file a motion to withdraw as counsel in those cases and ask?
Which case are you asking about, Judge?
The appeal.
So when
Ask for a hearing on that and bring it to the circuit court's attention, or this court's
the answer is no, I did not. I had the other person in my office, my assistant, call to inquire about that, and he was advised that they're not liberally granted, so we didn't take that course. And shortly thereafter, that's when we got the order from McMahon replacing habeas counsel.
Counsel, have you billed the state
No,
for
ma'am.
time
Not-
between June 25th and today, and until you prepared what you filed today?
Only for the time preparing what I filed today. So, I mean, I guess if what you're asking is there, patches of time throughout the summer on Augustus Gray, there are not.
Are there further questions? Do you have anything else?
I do not.
Your time has expired. Thank you, sir. This matter will be submitted.